Okay, everybody. It's now a few minutes after 2 Eastern time. Good afternoon or good morning, depending on where you're tuning in from. Welcome to what I call just like the 30 minutes fastest update I can give you so that it's chock full of good stuff, but not, not too long and not too tedious for you to sit through. Um, I do want you to know that we are recording as I speak. I will be attempting to learn how to create a YouTube upload from a partner who has done this, and hopefully these uh, presentations will be uploaded for available because I found that the file sizes are too large, and I can no longer uh, commit to emailing it to you because even just the audio file is too large. It won't pass through my filters, and so I'm going to try to do a YouTube channel. So anyway, thank you for attending. Um, I know most of you, and I thank you for supporting me and being here this afternoon. Um, as you, most of you know, I am a partner at Fisher Broyles. We are a national full service, what we call a distributive law firm, which is why it's a law 2.0. We are a radically different model than your traditional brick and mortar law firm. Um, we do have a lot of different practice groups. I'm not going to pitch you on all this, but I wanted those of you that are used to me handling your regulatory or your employment type matters know that we have a whole host of things I could assist with, or I have partners that do so if you ever have the need. Um, and so with that, I'm going to jump into the presentation. And what we're going to do is sort of pick up where I left off in the last presentation I did about um, what to expect with the election. So now that we've gotten certainty, we know that we have a new president. We know that the balance of the Senate has tipped to the Democrats by virtue of both Georgia seats going to Democratic candidates. And that, of course, clears a path for President Biden's agenda. And so let's see how my predictions have gone and where we are, even though we're not in the 100-day honeymoon period isn't over yet. I still wanted to get a gauge and kind of give you all a sense of where we are with some things. Okay, so let's see how my crystal ball did. All right, so first, I'm going to talk about OSHA. Look at these statistics here. So as of the last reporting period on the beginning of the month, over 13,000 COVID-related complaints for workplace safety. And then there were whistleblower complaints alleging retaliation for making such complaints. So COVID is real to your employees, and people are concerned for their safety. And it's very important that proper protocols are in place and reassurance that it's a safe workplace for everyone. And to that end, President Biden issued an executive order back last month to task OSHA to see if there's a need for emergency standards and temporary standards in place for COVID. And he gave a charge to do it by March 15th. Well, a proposed rule was just published in the Federal Register on the 15th of February. So I have kind of gone through it, and most of it is related more to manufacturers, importers, and distributors, but not employers per se. Most of it does pertain to tweaking of definitions of standards, and not as game changing. I can give you a roadmap of new things employers must do. Didn't come out in that manner. That being said, you can expect that safety, because of a pandemic and the prospect of a lingering COVID effect on our society, that you're going to need to revisit certain things with respect to safety. And so, as you see on the slide, I'm recommending updating handbooks in certain areas like safety and health policies, and reporting procedures, et cetera. And make sure that non-retaliation is emphasized, because you saw the whistleblower statistics I showed you on a previous screen, and it's real. OSHA is investigating. They're not afraid to come to your work site just because there's COVID. So make sure you're addressing this. even if you're not in a warehouse or manufacturing. Just general safety is important in any work site. I'm going to talk a little about Department of Labor, wage and hour, and related items now. So one of the items that is pending in Congress is Raise the Wage Act. It is a proposal to raise the minimum wage to $15 an hour by 2025. Some of you may have read that the Republicans will not allow it to be attached to an appropriations bill, and therefore, due to the manner in which they've raised it, it doesn't require the requisite normal majority. It would require 60 plus approval, and they're not going to get that. So probably this is dead. There is a competing proposal sponsored by two other reps that $10 an hour as a starting point, which obviously would be an increase over the current $7.25. If that doesn't make its way through, bear in mind, we already have 29 states and DC with minimum wages that exceed the federal $7.25. And this last legislative/election year, you see there are 3 states, California, Massachusetts, and Florida, that all have gone to a graduated $15 minimum wage already. So in some states, this will be the law anyway. We just won't necessarily have a consistent federally codified body of, mandate across the board for minimum wage. Another thing that the Biden administration has done is it has reeled back in a couple of the opinion letters that were issued right at the end of the Trump administration. These dealt with tipped workers and tip pool sharing arrangements, as well as determination of what constitutes an independent contractor. You can see what the DOL said, that it was premature. And this and a number of other proposed rules that had come out late in the Trump administration are now all on hold. The very first day Biden took office, he put a freeze on anything pending and wants to revisit. So it doesn't mean these things are dead. It means that they're going to create further contemplation, which means nothing's going to happen in the short run. So same can be said with the National Labor Relations Board. Right now, it is still Republican majority because of the appointments that go through the summer. Once that we hit the summer, you can expect Democrat majority in the board, which means some of the employer favorable NLRB decisions over the past couple of years, which I'm going to touch upon a few of them specifically, are going to end up being rolled back to the more favorable pro-union type policies, which includes potentially going back to scrutiny over handbook policies such as social media, electronic communications, dress codes, other type of policies where historically the board did not get involved with, but under a more liberal interpretation and more pro-union slant, these have been bases for unfair labor practice charges. So part of the way this is going to happen is that Biden basically got rid of the NLRB general counsel and a deputy GC and appointed Peter Orr to be acting GC, which is, he's a pro-union guy. So in turn, Orr then turns around and gets into rescission of 10 policy directives that came down under Rob, which means, again, rollback of a lot of these employer-friendly type interpretations. At the same time, many of you have probably read about the PRO Act. It's House sponsored. It is a very radical, far-reaching law that would amend the NLRA in a very significant way. So I'm going to take a few minutes and talk about some of the significant portions of that. Again, it may not pass in the Senate, but even if it doesn't come July, the board can do its own rulemaking. If it's Democratic, you can see some aspects of what I'm about to go over be implemented in just another manner. Couple of the more important ones, joint employer. So many of you probably know that joint employer standard under the NLRA has gone back and forth over the issue of direct, indirect control, the ability to, or actual exercise of such control. And um, the Browning-Ferris decision, gave a broader interpretation, and allowed, if you had the right to exercise control but didn't, like if you're a PEO and you have to say in your client agreement, we reserve the right of direction and control, you might be automatically a joint employer under that standard. The Trump administration reversed that, but the PRO Act would go back to that sort of standard. So obviously that makes it easier for companies working together, like a general contractor sub, a staffing company and its client, a PEO and its co-employer, to be more of a joint employer. So it's a problematic situation for employers if this is the direction it goes. The other thing that is included in this bill is the controversial ABC test out of California. And that is basically a test that talks about independent contractor determination. And as you see here, it's a very difficult standard to meet. In most cases, the test is going to fall short of establishing an IC relationship. The person is probably going to be considered an employee. And this really affects more the gig economy and folks that traditionally you would think work for themselves. But again, we don't know what's going to happen. We know in California this is law, but will this be adopted federally and put into the NLRA? We don't know. Chances are it won't, given the dynamic with the Senate. Let me go back. Wait 1 second. Okay. Now, there's a tweak to what constitutes a supervisor. If someone's a supervisor, they're not part of the protected employee class who can file unfair labor practice charges. There is a framework to make it easier to hold elections for unions to become the bargaining representative of the employees. And there is a preemption that this law would take precedence over the 27 states that have a right to work statute, which could require the payment of dues and other costs, regardless of whether somebody's in the collective bargaining unit or not. So it could have an impact on the employees as well. The one I think that is most broad-based and most practical / concerning to any employer is the fact that this law would bar class action waivers and arbitration agreements. Right now, under the Supreme Court authority, under the Epic Systems case, employers are permitted to require employees to sign arbitration agreements that would call for a waiver of the right to participate in a class or collective action. Typically, a wage and hour is a collective action. A class action might be for other types of claims, like Title VII, systemic discrimination, for instance. And of course, along with that line of thinking, if you can offer a mandatory arbitration agreement to an employee, you're not violating the law to terminate somebody or threaten to do so if they refuse to sign the arbitration agreement. This law would flip that all upside down and would not allow the use of arbitration agreements or class action waivers in these contexts, and would make it an unfair labor practice charge to threaten or coerce somebody who doesn't want to sign such agreement. So that's a game changer. Some of you on this call know I handle these type of cases, and I've had a great defensive strategy when I'm able to separate out multiple plaintiffs and make a plaintiff's attorney have to independently fight 4 separate cases. A lot of these wage and hour cases, the overtime amount they're looking for is very small, and it's not worth litigating if somebody's owed $100. And what these lawyers are doing is they're using it to collect attorney's fees because the FLSA allows for it. So anyway, that's a big one to me. Kind of switching gears a little bit. So many of you, I'm sure, have heard that the EEOC was going to revisit the employer incentives that can be offered as part of a wellness plan. If you participate in certain wellness plans, you get some cash or gift or a selection from a catalog or whatever. That's been rescinded again. it was going to be something where you could only do a de minimis incentive. The examples were like a very nominal gift card, like $2, or like a bottle of water for participating. They were toying with the idea that you don't want to bribe employees into doing something they don't really want to do. And so the question now has come up because, and I'm doing a lot of this too, is folks want to have either mandatory or voluntary vaccine policies in their workplace. And the question is, on the voluntary policy, can you incentivize employees to get them to agree to voluntarily get the vaccine for COVID? We don't know, because the incentive rules have been rescinded, and we don't know whether that's even appropriate to offer or not. But I'm having to wrestle with this. Meanwhile, we have no guidance, so something to be aware of. Another thing that is recent, EEO1 reporting. I have emailed, if you're on my e-newsletter, you know I emailed that the portal was supposed to be open on March 31st, that you've got 2019 and 2020 EEO1 reports to be filed for this year. But the EEOC has now postponed opening that filing period. We now think it's going to be in April, but there's been no official announcement. The best thing to do is just check their website periodically to see what the update is. And I certainly will, when I hear something, alert you. So if you're on my e-news alert, you'll get it. If you're not, at the end of this webinar, I've got information on, you can send me an email and I can add you to the list. Another bill that is circulating through the House, the way I would describe it, it's a sister law to Title VII. It would give another independent cause of action to the ADA or Title VII for pregnancy discrimination. And you see it would cover employers of 15 or more employees, and it has a reasonable accommodation requirement. This would just be another vehicle to adjudicate pregnancy discrimination. And so we don't know where this was going to go either, but it's a potential that you see it has similar damages recoverable as like Title VII. So we'll see where this takes us. A bill that just got introduced would also broaden Title VII. And this one relates to a topic that sort of got a lot of traction last year, and that's protection against gender identity and sexual orientation. So as you may know, the Supreme Court ruled in a case, Bostick versus Clayton County, which actually was here in Georgia originally, that Title VII extends protection on the basis of sex to gender identity, sexual orientation, so lesbian, gay, transgender Americans. This law would expand protections beyond on the basis of sex, which is the way under Title VII those protections are afforded. So it would again expand, provide a different cause of action, and it doesn't have to be necessarily just based on sex. They become now a separate protected class. Same dynamic though, it's in the House. We don't know what the Senate's going to do, and therefore it's a stay tuned. One other note, which surprisingly hasn't gotten a lot of publicity, SCOTUS, Supreme Court of the United States, heard the U.S. versus Texas case back in November. At the time, the Justice Department, of course, was under the Trump administration, and the argument and issue presented was whether the ACA's individual mandate was constitutional. And of course, since they've already made the oral argument, it would be expected that sometime in the next few months, the Supreme Court would announce its decision since arguments have been made. Well, when the Biden administration took over, it now controls the Department of Justice, and it told the Supreme Court that it no longer considers the ACA to be unconstitutional. So this is a reversal of that position. The Supreme Court can still rule on the issues and can still find it unconstitutional potentially. But the interesting aspect is that the Department of Justice is not supporting the position and isn't arguing it anymore, but in theoretically trying to withdraw its, but they've already had the oral argument. So I guess we'll see what happens. I think I would expect a practical solution, which is if the administration no longer wants to pursue it, you would think that the Supreme Court's going to come down and say it's constitutional. It also, from a practical standpoint, creates a lot of challenges to suddenly give people, they'd be without insurance. You're sort of, it becomes a game changer because we feel locked in over the years the ability to get this individual coverage. And I think it would be too problematic to try to start from scratch. But again, we'll see, because that's just my crystal ball. Another development that occurred in the last couple of days is that PPP loans. The SBA is now only accepting small employer applications for a 2-week period, which started on Wednesday. If you have 20 or less employees, you fall in that category. And essentially, the idea was that a lot of larger companies or conglomerates, et cetera, were availing themselves, and the money was getting used up in that way. And they wanted to give an exclusive opportunity to small businesses to tap into the funds. Now, note the funding program is supposed to end on March 31st in total. Obviously, that's not the 2-week small business. This is the program itself. There is talk of extending the program. There are discussions about, because there's been some uncertainty about how self-employed or independent contractors can determine what their loan amount is. There's discussion about not automatically disqualifying folks that have a criminal record, but a non-fraud felony conviction wouldn't disqualify, which right now it would. And note an interesting tidbit here, which is less than half of the $284 billion for this newest round has been exhausted as of February 18th. So there's still a lot of money out there for folks to apply. The other thing to note is the proposal to extend. It's like 10% of that $284 billion they're talking about adding. So it's a very small additional amount that there's a discussion on. Before I get to questions, I did want to add, there were a few other things that I read about, but after I put this presentation together. So along with this attempt to add a new appropriations bill, there's a discussion about extending tax credits and extending the FFCRA coverage. Now, if you have been following along, the Families First Act sunset December 31st of 2020, meaning the mandatory paid sick leave and emergency FMLA expired. And so through the first quarter of this year, through the end of March, employers can voluntarily continue to offer the FFCRA, but they're not required to do so. This was through an appropriations bill that was passed back in January. The other aspect of that was that employer tax credits originally weren't available to companies that applied for PPP loans. The appropriations bill changed that fact. And so you're allowed to go back in the fourth quarter to retroactively apply for tax credits. And then there's a tax credit for the first 2 quarters of this year. But the formula and methodologies are different. And it's way beyond the scope of this webinar for me to explain. But suffice to say, there's a discussion about reviving a mandatory paid sick leave and emergency leave. But as of now, it's not law. So we've used up a good bit of the 30 minutes, but not all. If anyone has any questions, use the chat feature right now, if you would, please. And I will do my darndest to try to answer, assuming it's somewhere on topic of what we're discussing. Okay. Let's see if there are any questions. I'm going to stop the share for a minute. All right. I don't see any questions, so I'm going to go back to my screen. So that's the formal presentation. It actually went a little quicker than I thought. So those of you who can't put the name and the face together, there I am. If you want to join my e-news list, you just email me. There's my email address there. I do periodically post on LinkedIn and Twitter. You can follow me on Twitter if you want. You can connect with me on LinkedIn. Obviously, if you enjoy these webinars, like I said, I will be soon making them available if this is a bad time for you, or if you miss it on YouTube. And then I will also like some feedback from you all on what other types of programs you'd like to see or subject matters. I'm also going to have some guest folks participate periodically because, some of you get tired of hearing from me and you may want a fresh voice, and I'm going to do that. All right, I see the new PPP for only small business. What determines if they're considered small? So, Rob, your answer your question is 20 or fewer employees. That's what constitutes a small employer for the PPP. Can you expand on the incentive portion of vaccines? Well, it's like this. If you don't want to mandate that everybody at your employer have to be vaccinated in order to enter the premises, you can offer something to the employees as an incentive to get the vaccine. There's no rule at this point on what that may be. It may be like a $10 gift card. It might be you're going to put everybody's name in a drawing who gets a vaccine to win, I don't know, some electronic. Or I mean, there's no rule at this point. I'm a little bit on the fence because, like I said, because they rescinded the wellness rules, I'm not real comfortable in saying you are not in violation of the law if you offer incentives. It's just not clear. But sometimes it takes a push. If your goal is to get people to take the vaccination because it's safer and it can reduce the spread of COVID amongst your workplace as well as amongst people in general, and you support the idea that it's valuable, then you want to push it, that's fine. But you can mandate it. There are parameters, and the policy has to be in conformity with not violating EEO laws such as ADA, GINA, et cetera, but or for a bona fide religious reason. But you can look at it from both perspectives. But incentive, it's just something you have to work with if you decide you want to go that route. And obviously, it's something that I'm trying to craft for clients. But like I said, since there is no guidance, there's no way for me to say you're safe if you offer $3 or something of nominal value, because there's no defined terms or methodology right now for you to be able to determine. So hopefully that made sense. Hang on, I guess we got time for one more question if there is one. No, it's a thank you. Okay, you're welcome. All right. Well, with that, then I'm going to conclude because I like to keep it 30 minutes because it's short, quick, and everybody has at least a 30-minute attention span because that's about the time we watch our sitcoms. So I appreciate it. As always, thank you for your support. If you're a client, I really appreciate you. If you're not a client, you can be if you want. And again, I'll be in touch again soon with my updates and another webinar. But if you have ideas or things you want me to talk about, let me know because I'm happy to cover something that's of interest to you. So with that, everybody have a wonderful remainder of their Friday. Enjoy your weekend, and I'm sure we'll be seeing each other.